Good morning, everyone, and welcome to our Primerio African podcast series and our engagement with African regulators across the region. This morning, we are very pleased to be joined by Siboni Maseko, the Director of Competition and Consumer Protection at the Eswatini Competition Commission. So I'm joined by my colleague, Megan Armstrong, and Siboni, good morning and great to have you with us this morning.
Good morning, Mike, and good morning, Megan. Thank you for having the Eswatini Competition Commission to be part of the series. We're very honored to speak about some of our enforcement experiences and the legislative reviews that we can look forward to. Thank you.
Great. Siboni, you joined the Commission, I think, almost a year to date. You'll correct me if I'm wrong. Coming from the COMESA Competition Commission, the regional body. Tell us what's life been like.
It's great to be home, first of all. It's great to be home after 8.5 years at regional level. It's good to be home, and it does feel like a homecoming because I was with the National Competition Commission before I joined COMESA. So it was amazing to be welcomed back by the team. The commission has grown since I was here. We now have a fully fledged consumer protection department. We have a fully fledged research and policy department. So it's fantastic to be back and to see the growth in the commission and, you know, some of the amazing work that the team has done over the years. And it's good to be part of that journey now.
Brilliant. Well, I'm sure the commission will only benefit from your experience at the CCC at COMESA, and great to have you at the agency.
Thank you.
For our listeners, for those who've been following the series, you'll know that what we really strive for in these sessions is just to have a frank and I suppose more informal discussion with our regulators for a variety of reasons, to get an update on key enforcement activities, priority areas, any legislative updates or policy developments. So there's no sort of prescribed script for this session. It's really to give, I suppose, you, Siboni, and the agency an opportunity to talk to us and to tell, you know, anyone who has interest in competition law, antitrust developments in Africa and in Eswatini in particular, a bit of an update and a bit of insights into what you and the agency have been busy with. So what I propose we do is we touch on some of the key themes that are always of interest to you know, any antitrust practitioner from an enforcement perspective, and flowing from that, we can maybe jump into a couple of the recent decisions and investigations that the agency has undertaken. There've been maybe a flurry of outcomes of decisions published towards the end of last year. You know, we're not going to have an opportunity to talk through all of them, but there are certainly one or two which I'd value your input and insights into, to the extent you're comfortable speaking to them. So perhaps we can tackle cartel conduct right up front. You know, being a key area of, I suppose, any antitrust enforcement activity. Talks a little bit through. I don't know, but you'll correct me if I'm wrong, if there have been any major outcomes or investigations concluded in respect of cartel investigations, but can you give us a little bit of an insight into what is the state of play in your cartel enforcement? Are there any investigations either instituted or that you're contemplating? Any techniques, investigative techniques that the agency is considering in-house? How's it been? Has it been successful? Are the tools being successful or not? Just give us a little bit of a flavor of what's going on in the cartels department of the agency.
Thank you, Mike. Our cartels department has been quite busy. In the last 2 or 3 years, we've concluded 2 settlement agreements, actually. One for the supply of school uniforms in the country, and the other for the supply of driving lessons in the country. So what we saw in the supply of driving lessons in the country was that the Association of driving instructions, like the companies that give driving instructors, I think. So they came together as an industry association, and then they agreed on the prices for the driving schools. And so when we realized that this was the case, we engaged them, we initiated an investigation, and the trade association was very collaborative over the course of the investigation. And what they chose to do was they chose to settle with the commission. And what that resulted in is we have a settlement agreement with them. There were no administrative penalties that were levied, but we did have to conduct compliance training with the association members just to make them aware and make them understand that agreeing on, the prices for driving lessons was anti-competitive, right? The second one that we had was in the supply of school uniforms. So this also manifested kind of like a vertical agreement, if you will, between particular schools that would identify one supplier for the supply of school uniforms. And what the schools would do is when students were enrolled, they would direct students to that particular supplier, even if the school uniform was by and large the same. So where you have mission schools, they would have the same colors for an Anglican school group or a group of Catholic schools. Or when you have national schools, they would, pretty much have the same colors, but parents would be directed to a particular supplier. And what we found when we investigated this was that it was also because of how the suppliers had come together and agreed that this is how that they should be able to supply school uniforms. And so again, that was something that we settled, and we're working with the Ministry of Education on that. The Ministry of Education issued a directive to the schools to indicate that they should not be directing parents to a particular supplier, and that if students are able to get the standard uniform in the correct colors, they should be able to do that from wherever they see fit and affordable and accessible, and not being directed to one particular supplier. So that was another settlement that we had. In terms of the tools that we have, settlement agreements we have used in terms of concluding agreement, cartel conduct. Our investigative tools, I'm not going to go into those because then the people will know. But we do have, we're trying to introduce a corporate leniency policy in the amendments to the bill. But we do have a framework for settlement agreements at the moment, and that has worked really well for us.
Yeah, I was going to ask you, that was going to be my next question, sort of where are we on the corporate leniency policy, and what do parties do today? A would-be leniency applicant in the current legal framework. We don't have a formal leniency policy in place. What is the sort of mechanism used? I'm sure the agency would still encourage parties to come forward and disclose wrongdoing. Talk us through a little bit about just what parties could expect if they were to approach you as of today, versus, of course, if there's a formal leniency policy that gives a bit more certainty.
Yeah. Absent a corporate leniency policy, Mike, it would be very difficult to have parties approach the commission because there is no legal certainty as to what will happen to them. It's common cause that if you self-report in the framework of a leniency policy, then you have the opportunity to discuss that the level of leniency that you can expect to receive. However, when we don't have a leniency policy, when we don't have that kind of framework, then it's a little bit risky for parties. And I don't think their lawyers would advise them to come through if they don't know what kind of risk they're exposing themselves to. So it is a challenge at the moment. Parties have not come forward to engage the commission on a leniency policy. So if we find ourselves initiating an investigation into cartel conduct, say today, then the framework that parties could possibly engage us on, if they so decided, was a settlement agreement, which would bring the investigation to a prompt finish, and we wouldn't see it all the way through.
Yeah, and look, that's not necessarily a bad outcome, I suppose, if parties have some comfort that they will get some favorable treatment from the authority if they were to come forward and divulge their conduct. And from your discussions on the earlier investigations where no administrative penalty was sought, it doesn't seem to me that the commission's point of departure in cartel cases is immediately a 10% administrative penalty and we work backwards from there. It seems that you take a bit more of a pragmatic case-by-case approach to a matter to try and ascertain, is it an administrative penalty applicable? Should you be a bit more leniency? And it seems like the commission has quite a bit of discretion in terms of how it will treat a case. Is that a fair assessment?
100%, it is, and we do have guidelines for administrative penalties and the setting of administrative penalties, and I can share that we have had a couple of cases, although not cartel cases, we have had a couple of cases where we recommended to the board a particular penalty, and they either didn't grant us the prayer on penalties, or they granted a prayer but on a reduced penalty altogether. And that is because we have the framework. The guidelines are public in terms of how we would calculate the penalties, but just to say that the board retains the discretion to, grant us at the recommended level or refuse to grant us altogether. So what I say that to say that we wouldn't immediately go for, the highest penalty being at 10%. We have our penalties to guide us on that, and the board retains the discretion to issue an order at a level that they deem appropriate.
Perfect. Siboni, you mentioned earlier there's a bit of a homecoming for you. So our two related questions. We certainly in the South African context, when the competition agencies came on stream, particularly after a couple of big decisions, big investigations, big penalties were issued, everyone took note, certainly the larger companies. And then over the years, what we'll start seeing is, companies are more aware from a compliance perspective, and they're more, I suppose, familiar with the competition principles and what governs good practice when it comes to competition law requirements. And then it notches up a step, and you start seeing how parties, both big and small, start utilizing the competition authorities in various manners. You see a lot more complaints of cartel conduct, of unilateral abuses. You see a lot more intervention in mergers, for example. You see parties, look and utilize, for example, in South Africa's case, public interest considerations. And you have all these dynamics that start playing out. From an Eswatini perspective, are you seeing more third parties engaging with the authority, particularly from perhaps a complaint perspective, than 5 years ago or 10 years ago? Is there any trend that you could speak to in that regard?
Okay, so I'll start with the compliance perspective. We are seeing an increase in compliance, especially from the private sector. Just this year, we've had a really successful engagement with the Bankers Association. And just a bit of background into that, we conducted a study into the retail banking sector, and we identified certain conduct that wasn't necessarily consistent with the Competition Act. But then, from a prudential perspective, the central bank hadn't picked up any red flags where that was concerned. But what the players then did in the market was we had an engagement with the Bankers Association to discuss our mandate, to discuss what the law provides, especially in terms of discussions by industry associations and the kind of conduct that is expected from a compliance perspective to competition compliance. And to that end, we have concluded a voluntary compliance program by one of the commercial banks, the private commercial banks. This was not in regards to any industry or association discussions per se. So it wasn't a voluntary compliance program that had anything to do with cartel conduct. And I want to make that very, very clear. But it was a compliance program in terms of some of the other vertical agreements that they have in the market. So they tend to have certain partnerships, across the sector. And some of the way in which those partnerships were framed were excluding competition or reducing consumer choice to an extent. And so we did enter into a voluntary compliance program with them. What we also saw was, for a regulated sector like the bankers, they do have a lot of compliance requirements on their side. So they tend to have in-house programs. And what we've done is we've looked at their in-house compliance programs, and we've confirmed that for our purposes, we're happy with these. If we had any recommendations to make those compliance programs more watertight where competition was concerned, the banks have been very happy to discuss with us on that point. In the private sector as well, we have also discussed with other players, for example, in the dairy industry, regarding, again, a compliance program, looking at some of the vertical agreements they're looking at getting into with, suppliers or producers of dairy products along the value chain. And we are looking at the private sector as we're looking at them for possible partnerships to see how we can get more voluntary compliance going from their end. So we have something in the pipeline, and I don't want to get ahead of the discussions that we currently have with the business community. So in terms of compliance, we are seeing an increase from the private sector towards trying to make sure that they comply with competition law requirements. From a complaints perspective, yes, we've also seen quite an increase of complaints. Some of the complaints are even coming into conduct that emanates from South Africa, where we have South African companies that engage a single distributor or a single service provider in our country, because the size of the economy makes it such that a lot of South African companies would consider us to be equivalent to a province or a region. And so they would identify one supplier. But what that would do is it would lock out possible competitors, and it would raise barriers to entry. And so we have had complaints against such particular conduct in the past, and we've been able to successfully adjudicate against agreements of that nature. So we have seen an increase in complaints on competition matters, as well as an increase in compliance, which makes us very happy as a commission, because we would want to encourage a culture of compliance, and so that the market can for itself fix anti-competitive conduct and not require an interventionist approach towards making sure that we achieve free and fair markets.
Excellent. Before I hand over to Megan to move to merger control, Eswatini Competition Commission is obviously a member state, or Eswatini is a member state of COMESA, and therefore you have a lot of interaction, presumably, with the COMESA Competition Commission. Can you talk a little bit about your collaboration to the extent you have with not just the CCC, but also South African Competition Commission, other regulators, and in the various capacities in which you are engaging? Is it in capacity building, best practice? Is it information sharing on mergers or on cartel conduct? What level of interaction are you and your agency having with other international regulators?
Okay. I'm just trying to take note of all of the areas that you mentioned so that I can touch a little bit on them and not go too much over the time that we've allocated. So cross-border cooperation and collaboration. I will start with the Triple C because, like you've mentioned, we are a member state of COMESA, and under our treaty obligations, we're required to collaborate with the COMESA Competition Commission. So the area in which we see the most collaboration between our agencies is on merger control, because the CCC is required to notify member states, and we submit our representations and market analysis into mergers that affect Eswatini. I think some interesting mergers that happened recently was in the prohibition of the AkzoNobel merger as it relates to Eswatini, where there was going to be a significant lessening of competition, as well as the divestiture in the Heineken-Distell merger, again, because it was going to be a significant impact on competition for us in the context of our economy. So that continues pretty well to date. And the second area that we see a lot of collaboration with COMESA is on capacity building. We do have COMESA hosts capacity building activities and events continuously, and they've continued to invite us to that. They have supported the Eswatini Competition Commission with a consultancy just in the last year to look at our legal review, to look at building capacity for us as an institution on technical matters. They've also sponsored study tours for our teams to go to Zambia to learn from that competition agency. And so we had an opportunity to learn from a peer authority on how they enforce against anti-competitive conduct, as well as consumer welfare and consumer protections. And then with regards to research studies, we have been part of the research initiatives that the COMESA Competition Commission does. Most recently, there was a phase 3 of the African Market Observatory identified Eswatini as a country that was affected in the sector that they were looking at. So that study hasn't come out yet, and I will not steal COMESA's shine, but suffice to say that we collaborated with them, we were on the ground with them, we went to stakeholders, we arranged interviews, we provided information, and that was a solid collaboration between our agencies. And then with regards to any anti-competitive practices as well, where they have an investigation that affects us as a country, they would send questionnaires for us to engage with the parties at national level, so that we can get an understanding of, the context of the market, what is the size, who are the players and their market shares, and then any competition issues that arise in that particular sector, depending on the theory of harm for that investigation, of course. And then on the consumer protection side, I know that this podcast was focusing a little bit on competition matters, but just, out of interest, we do collaborate with COMESA pretty well there as well, because whenever we have a regional product recall or a product safety warning, they would share with us as a member state, and we would make sure that that particular recall is implemented, or that consumers are warned or advised of any product safety measures that are being discussed at regional level. So our collaboration with COMESA has been, it's been very successful, and it has reaped tangible benefits for us as an institution, and we remain grateful for that kind of support. So that's on the regional side. When it comes to national cooperation with other national agencies, I will start by discussing cooperation and collaboration, if you will. Maybe not collaboration, so maybe assistance. Am I back?
Yes.
Okay.
Yeah, we can hear you, yeah.
Okay. my internet dipped. So it was maybe not collaboration per se, but assistance. When we investigated the complaint that was levied against the South African company, we engaged with our colleagues at the Competition Commission in South Africa. And we requested some assistance from them. We had hoped that we would be able to conduct a parallel investigation, but that isn't provided under their law. So we would have had to submit a complaint for them to look into this particular conduct and investigate this particular company. So we weren't able to run a parallel investigation. However, we were able to discuss kind of the dynamics in the market and learn from their experiences where that market was involved. We were also able to players in the market in South Africa and have interviews scheduled and go and meet parties and kind of have an understanding of how the market itself works, which was very informative for our assessment. And so that was helpful. And then on this particular investigation, we then received a query from another authority in the region, but not COMESA. And I will request not to name them because I don't know how far their investigation is and we wouldn't want to jeopardize it. But they were investigating similar facts as ours, and they wanted to know how we approached investigating a company that was not in our country and how we approached issuing an order. And what that determination looked like, because from an enforcement perspective, countries want to be sure that their orders will be complied with. And so that was very interesting for us in terms of cross-border collaboration, because we had gone through the process all the way to adjudication and imposing administrative penalties. Although we imposed the administrative penalty on the Eswatini company, we couldn't impose on the South African one because we hadn't cited them in the investigation. They were not a respondent. And so we were able to share our experience with that particular member state. And that is on cross-border enforcement. When it comes to merger regulation, we do have, under the Southern African Development Community, we have a working group. The working group is currently discussing a particular merger in the region where SADC country member states come together, discuss, that this particular merger has been notified and what are the issues that anyone is picking up. How are we defining relevant markets? Obviously, we have the larger economies looking at, different geographic scope than we would as a smaller economy. And so that's been interesting to look at and to see, because then we're able to have a live discussion with other countries on how they are approaching a particular assessment, so that even if we're not necessarily looking at imposing any remedies, it's interesting to see and to note how other countries are assessing a particular merger. Also, just to see how far other countries are with a merger assessment, how close are they to a decision, because sometimes parties give an impression that a decision is imminent in a particular country and they would want to request us to expedite that decision to allow them to go into implementation all at one go. And so having this kind of framework, even at SADC level, where we don't have an enforcement regime, this kind of framework is really helpful for our investigators to have an understanding about how other countries are assessing mergers, defining markets, and the theories of harm that they're looking at. Yeah, I hope I haven't forgotten anything.
Brilliant. No, very, very interesting. I've tons of follow-up questions, but we are limited to time. So I'm going to hand over to Megan, because I know we do want to discuss mergers with you, and I think that's a good segue to jump into mergers. So Megan, over to you.
Yeah, thanks, Mike. Siboni, I just wanted to figure out or sort of ask about what your merger trends have been like over the past year, 2 years. Are there any particular sectors that you're looking into, or where particular sectors where you've been notified of potential mergers? And then further to that, sort of, how does the Commission assess any public interest factors over and above competition concerns that are raised? I think you've got a particular focus on employment concerns and small businesses within your jurisdiction. So I just want to understand how the Commission considers those in their assessments of mergers and acquisitions.
Okay, thank you, Megan. So in the past 2 years or so, we've authorized 50 mergers, and 4 of these were approved subject to conditions. 39 of these mergers were local transactions, so there were mergers happening purely in our country, and 11 of these were mergers that we were affected because, for example, it was South African firms merging, but they would have presence in Eswatini either through offices or through by sales into the country. Common sectors for these transactions have been in the local market. We've had retail property has been quite active in the last 2 years or so. We've had mergers in poultry. We've had mergers in private security and food products, so franchise food outlets, dairy products. And then we've also had mergers in the hospitality industry, print media, and a little bit of tech here and there. So looking at payment systems and I think you would call them operating systems, but not like your computer operating system, but like systems that help businesses to run. I forget what the relevant market was in that one, but software, I think it's called software. Okay. And then in terms of our public interest issues, we are guided by our regulations, specifically Regulation 17 allows us to look at public interest issues. And you are quite right, Megan, the main themes there are, looking at the ability of small and medium enterprises to remain competitive, as well as the ability of a particular industrial sector or region to remain competitive in our export markets. And so after we conduct the competition test, so the standard for the competition test is a substantial lessening of competition. And when it comes to the public interest issues, we then look at, whether small enterprises can remain competitive as a result of this merger, and whether there's a particular sector in the country that needs to remain competitive in terms of its export markets. And to that end, we have looked at employment, but mostly from a sector perspective and not necessarily from at a micro level at transaction point. And so we've not issued a merger with employment conditions in the last year or two, but we have issued a merger in the provision of private healthcare space. We've issued a merger where where the parties, one of the conditions was the maintenance of employment. And obviously where we issue conditions, then we have to monitor those conditions. And so in our monitoring, it was reported that indeed some of those mergers were, some of them, those employees were maintained. So the conditions were, they were complied with. Most recently, we had a failing firm, and the firm was at risk of losing about 900 employees. And so they motivated for, part of the motivations, besides a failing firm defense, part of the motivations were that they needed to maintain this number of employees in the market, and the merger was granted. But we didn't have a condition to that merger. So that is to say that because of our ability to look at public interest considerations including employment. Firms have submitted merger notifications and motivated that it would go towards maintaining employment levels in the market.
Okay, wonderful.
Yeah.
Thank you. I had a quick question on the sort of foreign-to-foreign transactions. If there's a failure to notify to Eswatini, to your competition commission, how do you go about? Do you, if you hear about it through your regional body, the regional bodies that you're part of, do they approach the merging parties and flag that there's a notification required? What is the process there? Because it sounds like there are a number of foreign-to-foreign transactions that the Commission is dealing with. I mean, from historically and going forward. So I just had that question.
Yeah. So under the COMESA merger notification framework, we do have a reciprocal notification requirement. So what would happen is, if we believe that there's a merger taking place that should be notified at regional level, then we would advise COMESA Competition Commission. And I think the last time we initiated such kind of a notification from our end was in January this year, because we saw in our national media that a particular acquisition was earmarked. And when we looked at the companies that were involved, we thought that this might be a COMESA transaction. And so we notified COMESA to say, this is what we've learned in our national media. Do you know anything about it? And of course, what it turned out that the companies had engaged COMESA in a pre-notification regime. And so that notification was anticipated, and indeed, after the parties notified the merger, COMESA informed us of the merger. And at regional level, where there is a merger, that so, for example, if it was anticipated that it would be a regional merger, but it didn't meet the thresholds, but the parties had contacted COMESA somehow, then COMESA would notify us to state that your member state is involved in this in a transaction involving these parties. Maybe take a look and see if it should be notifiable in your country. So that is a mechanism that works pretty well with COMESA, because we have that reciprocal requirement for notifications. With some of our neighboring countries, we don't have the same level of cooperation that is formally agreed. And so we would rely on just a mutual understanding and reaching out to each other as colleagues to say, are you aware of this? And, that would typically be from a assessment perspective, so maybe even under the SADC protocol, to say, we've received this particular merger, let's discuss it, if it has been notified to you, yes or no. I think that answers your question, Megan. I'm not sure if I covered just the second part.
No, it does. Thanks so much. I think to sort of segue slightly into policy developments, I note that your filing fee for large mergers is about 0.1% of combined turnover or assets for the merging parties. And I'm just wondering if there are any plans. You mentioned earlier there's amendments coming up. I sort of want to touch on the timeline of those, whether we can know about the timeline of those, and whether there's any plans to adjust the percentage or cap amount on your filing fees.
Okay, thank you. We have had a competition bill in the pipeline since 2020, but when we went through the process of sharing it with our stakeholders for their comments, and when we then engaged the Ministry of Justice locally to see about tabling it before Parliament, it happened just at the point where we had a policy directive as a nation to say that we need to ensure that we have policies in place in order to support amendments or enactment of laws. And in the competition space, it was one of those areas where the law was enacted before the policy. So the law predated the policy, and that just kind of delayed having that bill submitted to Parliament for debate and enactment. And so we have then now been working with the Ministry of Commerce to try and get a national competition policy in place. And they've been very supportive throughout this as our line ministry. I can share that we've tried to go to market on this. However, the feedback from the market didn't satisfy the full conditions of the terms of reference. And so we've had to take it back to market. We are hoping that in the current financial year, the terms of reference will go back to market. So our financial year runs from April through March. So we are hoping that the terms of reference will go back to market and we will have a better response from the market, and we'll have submissions rather, that will meet all the requirements of the terms of reference. And so I think once we have the national competition policy in place, then we can see about moving forward with the amendment of the competition law.
That's wonderful. That's great. Thanks so much. Mike, do you have any further questions on the policy developments?
Yeah, I mean, I want to do, if we've got a couple of minutes, which I think we do, to pick up on these exclusive distribution agreements or arrangements, perhaps. Now, you gave a little bit of context regarding an actual distribution agreement. But there have been a few decisions that have been published, I think, towards the latter part of last year, maybe even earlier this year. Several of them focused on exclusivity in agreements and in different guises, different constructs. And it seems to be an area that the Commission is particularly interested in. I don't know if that is because that is where the majority of the complaints are coming from the market, or whether that is just an area where the Commission thinks there is a real concern. And I know we don't have time to go through all the cases, but there was a pretty interesting case, the Macmillan publishing case, which I'm hoping you could give our listeners a little bit of background to, highlighting just some of the key fascinating points about this case, and then I want to discuss a little bit about. I don't want to reveal all until you've given the background of the case, but then just to give us a little bit of time to discuss the remedies imposed and how we arrived at those remedies, because I think that was quite an interesting and calm-headed approach to what was a sensitive issue. But perhaps you could give our listeners a little bit of background to that.
Okay, thank you, Mike. So I will start by saying that exclusive agreements do tend to be quite rampant in our economy. So not only from multinationals identifying a single distributor or a single entity in the country to represent them, but we've also seen exclusive agreements, and I think the one that you referred to is the Macmillan case. So the Macmillan case, it came as a complaint, right? So it came as a complaint from a publishing company that wanted to engage with the Ministry of Education to publish and print primary school materials. So the background is, in the 1960s, maybe in 1964, the government entered into a publishing and printing agreement with Macmillan Publishing. And the intention of this was to allow the government to meet its constitutional objective of making sure that we've got a supply of textbooks at primary school level, right? And so in order to achieve this, the government entered into an exclusive arrangement with the publishing company, and we had only one at the time. And that arrangement it exists to date. And so we received a complaint against that because there was a printing company that wanted to bid to print the books. And they were unable to enter that particular service provision because the agreement with Macmillan was for publishing and printing. And at some point, I think an intellectual property defense was raised, right? But what happened was the printer persisted and the commission investigated this agreement between the Ministry of Education and Macmillan. And we did find that indeed it was locking out the possible printing companies, especially on the printing side. I think just to share that on the publishing side, it is a little bit tricky because the publishing involves curriculum design, right? And so in order for, uniformity and consistency, then, the government has, they would prefer just to deal with one publisher. And the publishing cycle, it has to look at an entire subject for the full phase of primary schooling from grade 1 all the way through grade 7. So to ensure that, the content in grade 4 links with the content from grade 1 and, segues seamlessly into the content in grade 7, they just really do have to manage that process really well. But from the printing side, the printers were of the considered view that it should be open. And when the case went to a hearing, one of the major issues that was discussed when it came to looking at the possible remedies for this particular, to remedy this particular exclusive arrangement was we needed to ensure that there was continuity of supply for textbooks for the children, especially because between 1964 and today, we've now had a free primary education regime in the country. And so we needed to make sure that the students maintain the supply of textbooks to the students is maintained, and that there's no disruption in supply. And so what the orders required was, well, the orders were that the agreement was anti-competitive, but that the government would have to do all positive things to make sure that by the end of the academic year, this year in 2025, that competition would be open for subsequent printing cycles. And so it was an interesting case, Mike, because of the constitutional objective that the government was pursuing, right? You really do have to make sure that there's access to education for your pupils, but also an interesting one from a remedies perspective, because you can't find the government. I know that there are some of our peer organizations in other countries have fined departments of government, but if we had pushed for an administrative penalty, it would have been an administrative penalty levied against central government, levied against the Ministry of Education, and that would do more harm than good. Because, at the end of the day, even though it is called free primary education, somebody bears the cost of delivering that service, right? So not only from making sure that the books are there, but making sure that the infrastructure is there to deliver free primary education. And so what we then did was we recommended that there should be a compliance program that we conclude with the Ministry of Education, which would involve training on our mandate as the Competition Commission, and as well as, some of the things that they need to look out for in procurement, once the procurement cycle is open and this particular service goes to open market. These are some of the things that they have to look out for. And we're happy to report that we've had several trainings with the Ministry of Education. We've had to have engagements with the Curriculum Center because they are part of the publishing side of, rolling out the service. We've had training sessions with the tender committee and the procurement committee within the ministry because they are part of procuring the service provider to print the books. And today, actually, we are with the Ministry of Education and possible suppliers in discussing what this order means for them, what they can expect to see, because when the board issued its determination, they observed that we can't have an abrupt termination of the arrangement because of how it can possibly affect pupils and their access to education. And so we really had to make sure that the current academic cycle is not disrupted by supply challenges, and therefore what can these possible bidders and possible suppliers look forward to in the next academic cycle and in the next printing cycle. So it's a case that was very interesting because it involved the central government. Investigating the government is no easy feat, but we're really grateful and appreciative for the collaboration, from the Ministry of Education and the Ministry of Justice as well, because the Attorney General's office was representing the Ministry of Education, and they have been keen on complying. We expect that we will continue to roll out some compliance trainings with them, for them, just to make sure that the orders are fully complied with. Yeah.
Thanks, Siboni. A fascinating case, and really sort of consumer harm, consumer welfare was at the forefront of developing and designing a remedy, as opposed to punitive deterrent approaches. And I thought that was a refreshing approach, perhaps, to dealing with the contravention.
Yeah,
I think that's brought us to the end of our session. There's a lot of content in there, Siboni. Thank you so much for sharing it so liberally with us, and I know there's a whole lot more that you can't share with us, but great to know that the agency is continuously improving its capacity, its resources, its a technical ability, and also just its thinking around new and novel competition issues. So look forward to seeing what the agency comes up with its new policies that it has in mind, and to working with the agency on future matters. Thank you so much for your time, and I'm sure all our listeners will find this fascinating.
Thank you very much, Mike and Megan, for having us as the Competition Commission. We look forward to seeing what the enactment of the policy and amendments of the bill will allow us to do in the future. But thank you very much for this amazing platform.
Thank you,
Great.
Siboni.
Thank you, everybody. Have a good day.
Thank you. Bye.
Bye.